verdict for Aaron Schmidt based on accident.
All right. There's your closing argument. Let me bring in session legal analyst and contributor Sunny Hostin and Meg Strickler, criminal defense attorney, joining me in studio. Welcome to you both. Thanks so much for being here. All right. This is the part that really struck me about this closing. And if I was the prosecutor, oh, man, would I just be ready to rock and roll after hearing this thing. But the word accident keeps throwing the word accident out there. I mean, I would spend a good 40 minutes explaining how all this wasn't an accident, Sonny.
Exactly. I mean, I've got to tell you, the facts are not helpful to the defense here, especially as the facts have come in, because we know that the defense didn't really put on that accidental defense. They didn't really give us real insight into what was in this young boy's mind when he pulled the trigger. It's not really disputed at this point whether or not he pulled the trigger. Just sort of the motivation is still disputed. But I don't think there's any evidence to support this version of events. And that's just a real missed opportunity for this defense team. I mean, I agree with you, Vinnie, having been on that side of the aisle. A prosecutor being faced with that kind of argument with a lack of evidence to support that accidental theory is going to go to town on it.
That's one of the great moments, you're like, oh, because what you're doing, you're listening to the closing argument, you're like, man, oh yeah. And whatever you had planned ahead of time, you are changing on the fly and getting ready to go to town on it. But accident is what we were talking about in the last trial that we covered. That was, okay, arguably an accident. This one, Meg, an accident?
Not so much.
I mean, it's not even close to an accident, plus there's the whole cover-up afterwards.
Not so much. And understand, when you're a defense attorney, you don't have to bring in your own case, but you can have thematically through the prosecution's case, through cross, you can bring in evidence, you can bring in your theme of the case. I wasn't hearing a whole lot of accident-type discussions in cross-examination earlier on.
No.
So now she's bringing it in here, and if I'm a juror, I'm going, I don't understand what's going on here. She could have done so much more. She's young. She's from a small county. I give her a lot of kudos for trying this very difficult case. But she should have done a lot more with his character, brought in so much more about his abuse. And then you can kill that premeditation very easily by saying, hey, this guy must have flipped. He must have switched. Who knows what happened? That's what happened. He did not premeditate. This was voluntary manslaughter. This was lesser included offense.
Well, you say those magic words, voluntary manslaughter. Let's go back to the opening statements. Take a listen.
We are confident the evidence will show that this is a case truly of a 14-year-old child who has been abused, traumatized, and neglected his entire life, who snapped. And because of that, we'll be asking you to return not a guilty verdict on malice murder, but on the lesser included offense of voluntary manslaughter. Thank you.
Okay, that sort of sets the roadmap, your opening statement. But Sunny Hostin, the closing argument, did you hear anything about voluntary manslaughter? Because I didn't.
No. And again, I mean, that's the issue here. When you make these arguments, you have to make them, they're informed by the facts as have come out during the trial. And it's great to ask of that, but you've got to be able to back it up. You've got to give this jury something to sink its teeth into when they go back into the jury room and arguably argue about whether or not there's evidence to support a lesser conviction. So I'm not quite sure where this is coming from. I mean, there were sort of glimmers of his dysfunctional background that came in, Vinnie, and sort of glimmers of this involuntary manslaughter count, but it's just there's not enough to support it.
Well, you're not going to get it if you don't argue for it, are you? At the end,
no.
Meg, don't you have to like say, "Hey, come back with this verdict, please, ladies"? It's your last opportunity to talk to him.
Exactly right. And again, you thematically bring that point throughout the case. You hammer it in at the very beginning through your opening, which you don't argue. You just bring it out, like you said, like a roadmap. But then you keep dropping it in like little teardrops in throughout the case, and then you sum it up like a little package at the end. It's textbook trial techniques.
Make it sound so easy.
Well, it's kind of a fun thing to do when you try cases, and try to do that. Now, you said sounds so easy. You try to do it.
Well, you make the attempt, whether you're successful or not.
Exactly.
It works out how it works out. Now, in this case, Meg, really what they're talking about is he's 14 years old. That's really the ultimate theme, right? He's only 14, okay? He's only 14, and he's had this troubled past. Well, how does that get you from point A to point B, and how do you have to do that inside a courtroom to let this jury fully understand, because, you know, prosecutors are going to have a completely different take
of course,
of who this is. And you look at him in the courtroom and, you know, he doesn't look like a scared little kid, really. At least to me, he doesn't look like a scared little kid.
He looks off. He does look off.
Absolutely, but most criminal defendants do. Okay? I'll leave it at that. But how do you turn this defendant into that 14-year-old confused child who's had a difficult life and make that into a true defense? Very
easily. You humanize your client. Very easily. You get a forensic psychiatrist on the stand and do a forensic evaluation, have him testify to that report. That's the first thing you do. Then you bring in family members, show that he's a product of incest. I mean, that by definition equals dysfunction. That is easy to show. He is his stepsister's son or something like that. I can't remember. He's a product of incest. His father's 70-something years old. I mean, there's so much going on in this family. If you brought any of that in through only one witness even, either himself or any of the family members, you bring any of that in and you show some of that dysfunction, the jury will have some compassion.
And that's what you need here, because factually you are stuck. You are stuck. So the case really becomes about who your client is and how we got to that point, and make this jury feel something for him. Let's take a listen to more of the defense closing argument here, just talking about, you know, what happened to this 14-year-old boy that caused all of this to take place, which was the shooting and killing of this innocent girl.
Purposes, for that better language, Aaron freaked out. That's what you see on the evidence. What the state is trying to show you is cold-blooded murder, is a traumatized, abused, neglected boy having realized that some tragic accident killed a girl he loved from a family he loved, and he lost it.
Okay, he freaked out, Sonny Hostin. That's part of the defense. I think there's you know, better ways to prove that in terms of evidence, but I understand the theme there. But then again, she comes back to this accident. The shooting was an accident, and if I'm a juror, I'm almost slapped in the face with that one. You know, there's no evidence that the gun accidentally went off or they were playing with the gun. No, he snuck up on her, shot her in the back of the head.
Yeah, and then dragged her out and lied all about it. You know, sometimes I think when you're so in the weeds of a case, you see things that perhaps you think that a jury sees or will see or has seen and the jury hasn't seen. I think that's where this defense attorney is. I mean, she knows her client, of course. She knows her client's backstory. She's hopeful that that has come across, but it hasn't. It's come across to her, but her job is to bring all of that in front of this jury, and it just didn't happen here.
All right, we're going to head back to the courtroom. Now it's the prosecution's turn to deliver their closing argument. Prosecutor Natalie Payne will make one last effort to prove that Aaron Schmidt planned and killed Alana Callahan on purpose.